A newly appointed lawyer for Simon Ekpa, Arman Dabiri, mistakenly published sensitive legal arguments online that should have been reserved for court, potentially undermining Simon Ekpa's defense in his upcoming Finnish trial. The leak detailed Simon Ekpa's defense strategy, including arguments about lack of Finnish jurisdiction, freedom of speech, political motivation, and international diplomatic sensitivities, all of which are now available to Finnish prosecutors in advance. The blog post was quickly taken down, but its content was retrieved and analyzed using online tools, showing a clear legal roadmap that Finland could now prepare countermeasures against. Arman Dabiri argued Finland has no legal right to prosecute Simon Ekpa for actions allegedly carried out in Nigeria, a critical but now prematurely exposed legal defense. The blog emphasized that Simon Ekpa's online comments fall under political expression protected by free speech rights, not incitement, again giving prosecutors time to craft rebuttals. In a seemingly unrelated but suspicious move, Nigeria's DSS denied involvement in Nnamdi Kanu's abduction from Kenya, despite being the agency that has held him since his rendition, raising further questions about legal accountability. A Finnish company, Wärtsilä, signed a deal to build a 30 megawatt gas-fired power plant in Lagos. The agreement was reportedly in progress around the same time as Simon Ekpa's arrest, suggesting possible diplomatic interplay. Some critics suggest Simon Ekpa is being used as leverage in Finnish-Nigerian relations to foster bilateral ties, portraying him as a scapegoat in larger political and economic games. While framed as a mistake, some speculate the leak might be a strategic ploy to gauge the Finnish government's response or to influence public sentiment, though it's a risky move. Meanwhile, some critics claim a South African activist has linked Finland's president to insurgency issues in Nigeria, hinting at deeper geopolitical implications yet to be fully explored. It is not often that legal battles carry the weight of international diplomacy and political undercurrents, but the case of Simon Ekpa in Finland is one of those rare, high-stakes exceptions. The story took an unexpected turn when Arman Dabiri, a newly appointed member of Simon Ekpa's legal defense team, made what many are calling a critical and possibly damaging mistake. Arman Dabiri published sensitive legal arguments online, information that was never meant to leave the secure confines of Simon Ekpa's legal strategy room. The content of that publication may have just tipped off the Finnish prosecution ahead of Simon Ekpa's court appearance. At the heart of this story is Simon Ekpa, a Nigerian-born political activist, controversial commentator, and a known advocate for the Biafran independence movement. He resides in Finland and has gained notoriety both in Nigeria and abroad for his online statements regarding the struggle for Biafran self-determination. For some, he is a freedom fighter voicing the grievances of a historically marginalized group. For others, he is an agitator fueling division and unrest. The Finnish authorities now face the difficult task of determining whether his actions constitute incitement or fall under the protected umbrella of political free speech. Simon Ekpa's case is currently moving through the Finnish legal system. However, his legal strategy was built around a carefully planned argument, one meant to be revealed in court, not the public domain. But when Arman Dabiri, a lawyer newly added to the defense team, published a blog post outlining Simon Ekpa's entire legal roadmap, everything changed. The blog post was initially published on a website associated with an academic institution in the United States. It was quickly taken down, but the internet never forgets. Legal observers, journalists, and even Finnish authorities were able to retrieve the document using online data tools. What they found was a comprehensive list of legal defenses, potential counterarguments, and even insight into the defense team's perception of the Finnish legal system. In effect, Arman Dabiri accidentally handed the playbook over to the opposing team. To understand the magnitude of this leak, it is essential to unpack what was actually contained in the blog post. Arman Dabiri made several key legal assertions on behalf of Simon Ekpa. First and foremost, he argued that the Finnish government lacks the legal jurisdiction to prosecute Simon Ekpa for alleged actions that occurred primarily in Nigeria. This is a cornerstone of the defense. If the court agrees, it would likely dismiss the case altogether. However, now that this argument is public, Finnish prosecutors have time to craft a sophisticated counterargument. They could, for example, demonstrate how Simon Ekpa's online activity, while executed from within Finland, had real-world consequences that transcended borders. Secondly, the leaked document emphasized freedom of speech. According to Arman Dabiri, Simon Ekpa's statements on social media were political in nature and should be protected under Finland's free speech laws. Dabiri suggested that Simon Ekpa was merely offering political commentary and not inciting violence. This is another key defense. But again, its early disclosure gives the prosecution time to reframe Simon Ekpa's comments as dangerous rhetoric with direct consequences, especially if any acts of violence or unrest can be traced back to his influence. Arman Dabiri also raised the issue of political motivation. He implied that the charges against Simon Ekpa may be politically influenced, either by the Nigerian government or by actors seeking to neutralize a controversial political figure. Such claims, if proven, could undermine the legitimacy of the prosecution. Yet, if prematurely exposed, they give authorities the opportunity to sanitize their case and present it as purely legal, devoid of political motivation. Beyond that, the blog touched on matters of international relations. It warned that prosecuting Simon Ekpa could complicate diplomatic ties between Finland and Nigeria, especially if the Finnish government appears to be acting under Nigerian pressure. This argument draws attention to the fragile balance of international law, diplomacy, and human rights. The leak has raised pressing questions within the legal community. Was this really a mistake by a careless lawyer, or could it be a calculated maneuver to force the Finnish authorities to reveal their legal hand as well? There are those who believe Arman Dabiri may have intended to provoke a response, using the leak as a litmus test for how far the Finnish prosecution is willing to go. Still, even if strategic, it is a high-risk move. Legal proceedings are not chess matches played in public view, and revealing your arguments early can seriously jeopardize a client's defense. This story cannot be viewed in isolation. Around the same time that this legal mishap occurred, the Nigerian government signed a power infrastructure deal with Wärtsilä, a Finnish energy company. The project, worth tens of millions of dollars, involves building a 30-megawatt gas-fired power plant in Victoria Island, Lagos. What raises eyebrows is the timing. The preliminary agreements for this project appear to coincide with Simon Ekpa's arrest and legal complications in Finland. There is growing speculation, some might say suspicion, that the case against Simon Ekpa may be a bargaining chip in a broader geopolitical game. Could Simon Ekpa be the human currency in a transactional relationship between Finland and Nigeria? Is his prosecution part of a quid pro quo deal to facilitate trade and political cooperation? Critics of the Finnish government and supporters of Simon Ekpa argue that he has become a sacrificial lamb offered on the altar of international diplomacy to smooth over Finnish-Nigerian relations. In this reading, his legal fate is not just about tweets and videos, It is about pipelines, gas turbines, and international contracts. It is about a small country like Finland trying to navigate the complex world of diplomacy with a larger, politically sensitive nation like Nigeria. Meanwhile, Nigeria's own internal contradictions are showing. In a recent court appearance involving Nnamdi Kanu, another Biafran activist, the Nigerian Department of State Services, DSS, made a puzzling claim. The DSS denied any role in Nnamdi Kanu's abduction from Kenya, even though the agency has held him since his forced return to Nigeria. This contradiction only deepens the suspicion that the Nigerian government may be manipulating legal frameworks to silence political dissidents. In a twist that adds even more complexity to the case, a South African political activist has publicly linked the President of Finland, Alexander Stubb, to insurgency-related issues in Nigeria. Though the nature of this accusation is vague, it hints at deeper geopolitical undercurrents that are not yet fully visible to the public. If Finland's head of state is being dragged into the conversation, the stakes are clearly rising. So, what will happen next? From a legal standpoint, Simon Ekpa's defense is now exposed. The Finnish prosecution will likely study Arman Dabiri's blog post in detail, preparing counter-arguments that could seriously weaken Simon Ekpa's position in court. The court may also view the publication as a breach of legal decorum, potentially penalizing the defense team or questioning their professionalism. From a political standpoint, this case could become a flashpoint in Finnish-Nigerian relations. If Finland is seen as prosecuting a Nigerian political dissident on behalf of a foreign government, it could face backlash from human rights organizations, free speech advocates, and international observers. For Simon Ekpa himself, the road ahead is uncertain. He remains in custody, facing legal charges in a foreign land, while his name is at the center of an international controversy. His supporters argue that he is being unfairly targeted for expressing political views. His critics see him as a dangerous provocateur. And in the middle of it all stands a blog post, one that was never meant to be read by the public, but now might shape the outcome of a landmark legal and political saga. As we continue to follow this story, one thing becomes clear. This is not just about a man, a lawyer, or a leak. It is about how nations use law, media, diplomacy, and power in a globalized world. Simon Ekpa's case might one day be studied in law schools and political science courses as an example of how legal proceedings can become entangled with geopolitics, and how a single misstep can change the course of a trial. Only time will tell whether this leak was a tragic mistake or a clever gamble. Until then, the world watches Finland, Nigeria, and Simon Ekpa with bated breath. After the controversial blog post by Arman Dabiri surfaced online, only to be swiftly deleted, the Finnish legal system entered a phase of heightened scrutiny. What should have remained internal strategy discussions within Simon Ekpa's legal defense team became publicly accessible information. And although the original blog was scrubbed, the internet, with its nearly permanent memory, ensured that the content was captured, archived, and analyzed by both amateur sleuths and professional prosecutors. This event has led to an extraordinary legal situation. Prosecutors now have the rare advantage of foresight. They have been shown the roadmap that Simon Ekpa's team intended to use in court. In any legal contest, especially one involving such a high-profile defendant, the element of surprise can be crucial. Legal teams guard their arguments like state secrets, especially when the case has political, diplomatic, and international implications. For this reason, the leak has not only undermined Simon Ekpa's legal strategy, but also potentially tilted the courtroom dynamics heavily in favor of the Finnish state. But what exactly did this leaked blog reveal? Let us reflect once again on the core pillars of the defense that Arman Dabiri laid out. The first was the assertion that Finland lacks jurisdiction over Simon Ekpa's actions since the alleged offences occurred in Nigeria. At face value, this is a compelling legal argument. Nations generally only prosecute crimes committed within their borders or involving their citizens. Dabiri's position was that prosecuting Simon Ekpa for actions carried out abroad, particularly in a sovereign African country, would exceed the Finnish judiciary's remit. However, prosecutors now have time to preemptively argue around this. They could, for instance, invoke legal doctrines of extraterritoriality if they can prove that Simon Ekpa used Finnish infrastructure, like servers, bank accounts, or even his residency status, to further his goals. In that case, Finland might justify prosecution not because of where Simon Ekpa acted, but because of where his influence originated from or was amplified through. The second argument centered on freedom of speech. Arman Dabiri argued that Simon Ekpa's statements, however controversial, fall under protected political expression. Finland, as a European Union member state, enshrines freedom of expression, and its laws are among the most liberal in the world in terms of civil liberties. Yet by publicly announcing this as a primary defense argument, Arman Dabiri effectively gave Finnish prosecutors the opportunity to begin collecting evidence that reinterprets Simon Ekpa's speech not as political discourse, but as incitement. This leads us into the delicate area of interpretation. Whether a statement is deemed political expression or incitement can depend on context, tone, platform, and, crucially, public reaction. Finnish prosecutors can now comb through Simon Ekpa's online posts and public communications with renewed intent, building a case that shows causation, that Simon Ekpa's rhetoric led to real-world violence or disruption in Nigeria. The longer the prosecutors have to prepare such a counter-narrative, the more sophisticated their argument could become. And so, this blog post becomes more than just an accidental release of information. It is a live wire pulsing with legal electricity. Some have begun to wonder, could the leak have been deliberate? If so, what would be the motivation behind such a move? One theory posits that the leak was a strategic feint. By publishing these arguments, Arman Dabiri might have intended to test the Finnish government's reactions in real time. How they respond, through legal filings, diplomatic statements, or media briefings, could give Simon Ekpa's team insight into the weaknesses of the state's case. If the state tips its hand, then Dabiri and his colleagues might adjust their final arguments in court accordingly. This theory, while bold, is not implausible. High-stakes legal defenses have historically employed unorthodox methods. However, it would be a deeply risky tactic. It assumes the Finnish prosecution would react publicly and in a predictable way. It also assumes that the damage to Simon Ekpa's case would be outweighed by the intelligence gathered through this move. It's a gamble, and the stakes are not just personal, but political. As we pivot from legal intricacies to political and diplomatic layers, we find a broader web of implications beginning to emerge. This incident occurred amid rising speculation that Simon Ekpa's legal troubles are more than just about alleged crimes. They are about leverage. Around the time of his arrest in Finland, a major Finnish company, Wärtsilä, finalized a multi-million euro deal to build a 30-megawatt gas-fired power plant in Lagos, Nigeria. On paper, this is an industrial project aimed at improving Nigeria's energy infrastructure. But in the shadow of Simon Ekpa's arrest and legal turmoil, some analysts are beginning to see this as a form of soft diplomacy. Nigeria, through back channels or quiet nods, may have indicated a willingness to deepen economic ties with Finland in exchange for Finland taking a tough stance on Simon Ekpa. The logic behind such a move would be both strategic and symbolic. By arresting and prosecuting a controversial Nigerian-Finnish activist, Finland could signal goodwill toward the Nigerian government, a way of saying, "We're listening, we're cooperative, we're open for business." That would make Simon Ekpa not merely a defendant, but a bargaining chip, a human token in a transnational negotiation. Critics have called this dynamic a case of scapegoating. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.